which is probably, Mr. Royal, why you say, or think, well, every night we might see little snippets. But the media knows the forum in which they can ever put that out as to the public. They know the forum in which people's identities need to be protected, because there are times when people who may testify cannot have their identities shown publicly. They also know they can't just post those anywhere they want to post those recordings. So there are certain rules and restrictions, even if the court allows the news media to come in and record hearings, about where they can then subsequently go and post those recordings to. Do you understand?
Yeah, I get it. I got you.
Okay, so why don't you set up your audio recordings? But I just wanted to make sure you knew that if you want to cite to the transcript or the record ever, that's going to have to be done through the court reporter, because I can't guarantee the recording devices you're going to use will capture everything that's said.
Yes, but after going over a lot of the court reporters, after getting the paperwork and going over a lot of the court reporters, everything has not been documented or documented correctly. I do want to.
If you've received a transcript and you have an objection to a portion of that transcript, then you need to file that with the court.
Okay.
But her job literally is, the moment once I start saying, please be seated, and start talking, she takes down everything that's said, unless I say, we're gonna go off the record for a minute. And we sometimes do that when we're trying to pick court dates, because otherwise there's all this kind of gobbledygook on the record about this date and what works and what doesn't work for people. Okay?
All right.
So go ahead and set up your audio recording equipment.
I've set it up.
Okay, perfect. All right, I didn't know it was that quick. Thank you. All right, so let me review why we are here. Ms. Sturts, you filed first an affidavit in support of your request for sanctions and a request for a sanctions hearing. And Mr. Fontaine, or I'm sorry, Mr. Royal, you filed a request for a revision of judgment because Brooke Fontaine has sole custody. You want a review of that. It related to the supervised visitations. I think we've been here once earlier when Attorney Bouchard was also present with us. I'm correct in that, am I not, Attorney Bouchard?
That's correct, Your Honor.
Okay. So there was a hearing held before the Family Court Commissioner regarding an item review on December 30th. Mr. Royal asked for a de novo on that, which I tried to schedule all of this for one hearing. First, let's go on his de novo request, if that's okay, Ms. Sturts?
Fine by me.
Okay, so what was reviewed, you requested more time for additional visits. The matter was heard downstairs, but basically we start in some ways all over when we're up here. So Mr. Royal, is there information you want to present to me on that request?
Yes, I have a testimony that I would like to present.
Okay.
Instead of me going through and reading the paperwork, which I can if that's what y'all like, I have prepared a speech through my computer, if that's okay.
It's not going to be for my court reporter to be able to take it down, because for her,
It'll be the same. It's word from word. I'm gonna read it word from word, or it's gonna be read from the computer word from word. It just stopped me from stumbling over words, so she can be able to report it better.
well, I don't want to do that. For example, I'll give you this example, Mr. Royal. When the state uses a 911 call in a criminal case, we don't have the court reporter try to take down that audio recording, because often things are said fast, or there's just other background noise, or the quality isn't good. So I would require the state to provide a transcript of that 911 call and bring that in. So I would rather have you read it. Don't worry about stumbling or being nervous, that's okay. But I don't want a statement played because it's gonna be near impossible for the court reporter to take it down.
Okay, I have slowed it down though, so that it's at regular speech. And I did bring a speaker too, so that the whole court can be able to hear. But if that's still not fine, then I'll go ahead and read off of it.
Okay, we're gonna go on a break just so I can confer with my court reporter for a minute. I think consistent with what we tell you, rather have him say it, right, than try to take, yeah. Yes, we could do that too. Okay, we're gonna go back on the record. The court reporter said, and this is someone with, I won't say how many decades of experience, but lots of experience. It's too difficult to try to take down a recording, even though you've tried your best to slow it down. What I can do, Mr. Royal, is if you have what you're gonna say, I can also make a copy of that and we can mark it as an exhibit. So it's part of the record, if you want me to. But why don't you tell me what you want me to know then?
All right.
Your Honor, I would
Yes.
just ask that Mr. Royal be put under oath.
Yes, we should do that first. I'm gonna have you testify right where you are. It's just easier. You have your notes in front of you. Could you please stand and raise your right hand?
Do you solemnly swear the testimony you will provide will be the truth, the whole truth, and nothing but the truth?
Yes. Now is Brooke gonna be put under oath too, even though she's not?
Yes. So you can be seated. And then if you want to either slide that microphone over a little bit in front of you or sit a little closer, that'd be great. I'm gonna check our audio controls. I may turn your mic up too, just a little bit. Okay, go ahead, Mr. Royal.
All right. Wisconsin Stat 767.145, factors in custody of physical placement and determination. The court may not prefer one parent or potential custodian of the other based on sex.
You gotta slow down just a little bit.
Okay.
That's okay.
My
The
computer
court may
will.
not prefer one party.
The court may not prefer one parent or potential custodian over the other based on sex, race, or the potential of the custodian. Wisconsin Stat 948.31 4A is an affirmative defense for is an affirmative defense for violation of the sanctions if the action is taken by a parent or if the action is taken by a parent or by a person authorized by a parent to protect his child from a situation in which the parent or authorized personnel believes that there's a threat of physical harm or sexual assault of a child. 2. It's taken by a parent fleeing a situation in which the parent reasonably believes there's been a threat of physical harm, sexual assault, sexual assault to himself or herself. It's considered to be it's consented by the other parent or by a person or by any other agency having legal custody of the child or otherwise authorized by law. On March 23rd to the 24th, 2018, I, Sebastian Royal, called the police for a domestic dispute involving myself and Brooke Fontaine. Brooke Fontaine was acting belligerent, damaging property in which I own, forcefully kicking me while dangling our premature son, Sebastian, off the side of the bed. After the police arrived, they asked if we would separate for the night. I informed the police officers in Brooke that I'll be taking my son to Wisconsin to Milwaukee to my mother's house, who has babysat for us on several occasions. Wisconsin Stat 767.412 AM, custody to a party or custody to a party, joint or sole. Accepted as provided in Part B, the court shall presume that joint legal custody is in the best interest of a child. Wisconsin Stat 767.145, factors in custody and physical placement determinations. The court may not prefer one parent or other potential custodian over the other based on sex. I've read that one. Brooke Fontaine and her attorney Sarah requested emergency custody placement with no trial on March 27, 2018, based on a motion of 767.822M. During this time, our son Sebastian, Brooke, and her oldest son were living with me. I was the only one working. I was the main caregiver, not just to my son Sebastian, but also to Brooke and her oldest son, which, with there being no justification and lack of evidence on Brooke's behalf, par Wisconsin Stat 767.412 AMD, and due to the factors supporting Wisconsin Stat 767.145 in the best interest of Sebastian, joint legal custody should have been awarded equally to both parents. If not, sole custody should have been placed under the main provider and caregiver, which was myself at the time. The court decided to grant Brooke emergency sole custody based on sex. During the hearing on April 10, 2018, after testifying from both sides, Commissioner Richard Rowland would state that due to the lack of evidence, he would not make a decision regarding the placement of Sebastian, and that the assigned judge would make that decision. During this case, I informed the court, Brooke and Child Support Services, that that before the incident on March 23rd, 2018, I gave notice to my employer that I'd be switching jobs. I had an interview on March 26th, but due to the circumstances, I did not get hired for the new position, and I was replaced at my current job. Because I was unemployed and because Brooke took $3,000 I had put in the house for rent and child supplies, I informed the court that I would be moving to Milwaukee. The court commissioner then asked Brooke and Party if they had any concerns or objections to me moving to Milwaukee. Brooke and their attorney, Sarah, would state that they had no objections. I would also note that I had brought bank statements and evidence and notified the court of the bank statements on several occasions in which none of my evidence was taken into consideration and would later be denied. During the hearing on May 31st, 2018, after justifying my cause of the situation, Guardian Lion Brian Bushaw, Judge Kerry Snyder, refused to acknowledge any of the evidence and facts that I had brought, including a police report which was filed, only acknowledging that the child was taken, and that Brooke would proceed to call the police. A text message was brought up to the court by attention by Attorney Sarah. My bad. Brian Bushaw reported that he felt that it was unsafe that I, a male father, travel any distance with my son, right after recommending that supervised visitation should occur, in which Brooke, the female mother, traveled several distances a week with our son. He would also state that he disapproved of me moving to Milwaukee. I objectively stated that my son has passed the hospital car seat test, and that there was no law or rule of how far one can travel with the child, and that people co-parent children of all ages regardless of the distance. At the end of the case, I asked the court what was the reason for giving Brooke sole custody. The court gave no other reason than Brooke being the mother of the child. During this hearing, Brian Bushaw refused to acknowledge situations, contradicting the statements, only acknowledging what was in the best interest of Brooke, not Sebastian. Wisconsin Stat 757-22. Judge may not act as attorney. Judge not acting as attorney. Attorneys not having offices with judge. This is 1. No judge holding office may in any manner engage in acts as an attorney or counsel, and no judge and his clerk or any person employed by the judge and or his office or commissioner or judicial office shall give any advice to the parties in any matter or action before the judge. Which judge has reasons to believe that it will be brought up to him or her for decision or draft paperwork, including wills. Wisconsin Stat 9013, rulings and evidence. In erroneous evidentiary ruling is reversible if a substantial right to a party is affected. Effects of erroneous rulings. This is one. Since error may not be predicated upon ruling which emits exclusive evidence unless a substantial right to the party is affected. Objections. Objections in cases of rulings is admitting evidence in a timely, objective, or motion to strike. Motion to a strike appeal or of record, stating the specific grounds of the objections. If the specification grounds was not apparent or in context. Offer of proof. In case of the ruling of one excluding evidence, the substance of the evidence was made known to the judge by offer or apparent from context within the questions that were asked. 2. Record of offer in ruling. The judge may add any other further statements which shows character of the evidence forms which was offered, the objections made, and the ruling thereon. The judge may direct the making of any offer in questions or forms. 4. Plain error. Nothing in the rule precludes taking notice of plain errors affecting subsequent rights, although they were not brought to the attention of the judge. Wisconsin Stat 9014. Relevancy conditions on facts. When the relevancy of evidence depends on the fulfillment of a condition or fact, the judge shall admit it upon or subject to the introduction of evidence significant or support a finding of a fulfillment of a condition. On July 13, 2018, I wrote a letter to the court asking for a review of the case in front of a judge. The court date was set for August 6, 2018. During this case, I was asked by Judge Carrie Schneider what was the reason for wanting to reopen the case. I answered I wanted to review the past case because I did not believe that the laws were followed correctly and that I wanted to go over new evidence. The judge then asked Brooke and her attorney Sarah if they had any concerns about what I was asking. Attorney Sarah replied that there was no issues with reviewing the past case. I asked the judge if I can call Brooke to the stand. The judge defended Brooke by stating she did not believe that Brooke and her attorney was prepared for the case. Then turned to Attorney Sarah asking if she agreed. The judge then stated she would not review the past case, and the judge then stated that she would not review the past case and that I had to produce new evidence. I then stated that I had pictures, GPS locations, text messages, along with other documents that I would like to show the court. The judge replied that the text messages were not an accurate source of evidence, and that I had to provide new evidence after the date of the hearing on May 31st, 2018. I would like to note that on April 23rd, 2018, the guardian ad litem, Brian Bushaw, would instruct me to ask Brooke to send pictures and updates. Also, on July 6, 2018, during the court hearing, during the court hearing with Commissioner Mark Schroeder, Brian Bushaw and Attorney Sarah felt that it was a concern that I had not attempted to ask for pictures and updates. Brian Bushaw stated that because no visitations had occurred, he could not give a recommendation. He would also state that I would send the same text messages day after day with no change, asking for pictures and all updates concerning the child. Brian expressed that he disapproved of the messages that was sent because I was concerned for my child. He would then go on to state that Brooke has shown she is willing to work with me by only sending picture messages and doctor appointments via text. I would then state that Brooke would alternate between sending the same set of pictures, sometimes three or four. Sorry about that, I'm gonna reset it. I then stated that Brooke would alternate between the same set of pictures, sometimes sending me the same picture 3 or 4 times in a 5-day period. She would refuse to give me any updates besides our son's doctor's appointments, and would even change his doctor appointment so that it would cross against my work schedule. I then requested to show the messages to the judge, in which the judge stopped me and defended Brooke by stating that Brooke is not required or obligated to send me any information, and if I could not produce any new evidence, the order still stands. I further asked the judge what was her reason for giving Brooke sole custody. No response was given other than Brooke being a mother. During this case, Brian Bushaw still refused to acknowledge situations while contradicting his statements, only acknowledging what was in the best interest of Brooke, not Sebastian. To sum this section up, I have placed defending Wisconsin stats besides the statements that have occurred. 757.221, the judge acted as an attorney by persuading and defending the petition after party agreed to the terms of the review. And during the case on May 31st, 2018, the judge accepted evidence that was presented as a text message from the opposing party. Wisconsin Stat 901.031 and B, Wisconsin Stat 901.04, but now would deny me the same presentation of evidence, regardless if the evidence was showing a fulfillment of condition or substantial
Excuse me, could you repeat that part? Same presentation of evidence regardless if the evidence
were showing, if the evidence were showing a fulfillment of a condition or substantial right of a party was affected. Then letting the guardian ad litem present a testimony based on text messages he received from the opposing party, in which it was not denied but taken in for consideration. Wisconsin Stat 901.3a, in my defense, for my defense, sorry about that. Okay. And for my defense or objection to the guardian ad litem's testimony, I asked to show the messages to the court. The judge again denied me the opportunity. 767.41 2C. The judge states that Brooke does not have to cooperate. In Wisconsin Stat 767.14.5, the judge gives no reason other than Brooke being a mother. I would like to state that I have notified Brian Bushaw on several occasions of the inaccuracy of the knowledge of the situation and including documentations. During the hearing on October 30th, 2018, in front of the Commissioner, Mark Schroeder, guardian ad litem Brian Bushaw would still refuse to acknowledge situations, only acknowledging what was in the best interest of Brooke, not Sebastian, by inaccurately stating that the child was taken to Milwaukee and that Brooke would later proceed to call the police. He would state that I moved to Milwaukee without notification. During that time, no visitations had occurred. He would then go on to state that visitation started September 25th, 2018, and lasted almost a month's time, and the visitations went well. He would then state that he would then state that my concerns for my sons being dressed properly for the weather, my concerns about my son's bottle provided by Brooke, which was a choking hazard, and my concerns for the cleanliness of the facility was disrespectful to Brooke. After Judge Carrie Schneider, has stated that she would not consider any messages as a form of evidence prior to the case, he would then state that more text messages had occurred, which he felt that had badmouthed Brooke. He would also state that he does not believe that a 1 month visitation was enough time to give a recommendation. In my defense, I objectively said that the information he received from Megan from Parent Connections, the information they received was from Megan from Parent Connections. Megan spent approximately 3 hours of visitations. I did not believe that she could accurately give a report due to this. The majority of our time was spent with a temp for Parent Connections. Communication between Megan and Mai was very poor on several occasions, caused confusions, including times, dates, feedings, and general information. Mai will most times ask me questions that should have been notified to her prior to the visitations. In most cases, I would not be able to answer because I was not notified. With that being said, I still do not believe that Megan could not give an accurate report because she was barely involved with the visitations. Mai should have been the one to give the report. I also stated that Judge Carey stated that she would not consider messages of a form of evidence. Brian originally scheduled the visitations to last approximately 1 month after the first hearing with Judge Carey. But now would state that the same amount of time is not efficient. I also stated that since visitations had occurred and there has been no threat, sorry about that. I've also stated that since visitations had occurred and there is and has been no threat concerning my ability to take care of my child, I should receive full custody of Sebastian and make up for the time that was lost. Commissioner Mark Schrader would then state that no changes will be made to the order and that supervised visitations will continue. This case has been biased, sexist, poorly documented by the reporter, showing one-sidedness in the interest of the plaintiff, along with many other things but fair. Due to the accusations and testimonies and law stated above, I have requested an investigation from the Wisconsin Judicial Commission. Due to the erroneous ruling on March 27 and due to and all that applies above, I am requesting sole custody.
I'm sorry. And erroneous ruling on March 27th.
Yes.
And
I'm gonna start from the beginning of that one. I have requested an investigation by the Wisconsin Judicial Commission due to the erroneous ruling on March 27 and all that applies above. I am requesting sole custody until further investigations have occurred. Due to Wisconsin Stat 757.22 and all that applies above, I am requesting that Judge Schneider recuse herself from the case and that the guardian ad litem Brian Bushaw be replaced due to the contradicting testimonies and failure to acknowledge key situations. and due to Wisconsin Stat 901.031 and all that applies above, I am requesting that a new case be opened in front of the jury to protect myself and my son I am requesting that a new case be opened in front of a jury to protect my son and myself from the emotional and physical damage that the court has caused to our relationship. With that being said, I would also like to state that sorry about that.
Okay.
With that, I also like to state that I'm willing to go as far as I need to go to get custody of my son. If I have to protest, if I have to stand out in front of this building, if I have to go to news reporters, if I have to go all the way up to Washington D.C. and fight to get the law changed, I'm willing to do that, to get custody of my son. I've been to my son's doctor's appointments. I kept up on my son's birth-to-3 appointments, which is not needed because my son is not disabled in any type of way or has been disabled in any type of way other than him being born prematurely. His birth-to-3 appointments and all of his stats are perfect. In some cases, they're perfect. My son is perfect. There was one other thing I wanted to say too. But Your Honor, I'll be honest with you, I'm pretty sure that the court has already made up their decision or already had their mind made up before I even walked into this court case today. So with that being said, I have nothing further to say. And y'all can make y'all decision.
Well, part of the question that I wanted to know, Mr. Royal, when you file these requests, and part of what I looked at yesterday and last night was to try to see the sequence of what has happened. And when there is a request after the court makes a decision to change something about that decision or to modify, because we have those come in all the time. We have a certain schedule and now someone's asking to change or modify that, is I want to know what's happened in between. And part of what you've just read and stated are some of the same complaints and issues about what you feel is how I first decided the issue in the case. And I think on September 7th, when we were here, we went through much of the same issues and your objections that I've heard today. First, I think in your letters, you request that the court recuse myself. I do not find any reason to do so. Based upon your request, I'm going to deny that request. You request guardian ad litem Brian Bouchaw withdraw or that I appoint someone new. He has to take the information he gets and make a recommendation. You don't agree with some of his recommendations because you think maybe he's not listening to things a certain way or he's weighing someone's opinion or testimony greater than others. That's the role of a guardian ad litem in every case, is to try to listen and gather facts outside of the courtroom for the courts. So I don't find any information in what you've presented to have him removed from this case or appoint a new guardian ad litem at this time. I think, and whether you remember Sebastian or not, at one of the last hearings, he was complimentary of interactions and notes he had and things he had about your interactions with your child. But I understand he's also come in and said things that you don't agree with or that you think aren't in your favor, but that doesn't give the court a reason to have him withdrawn or removed from the case. Ms. Sturts, would you like to respond at all in respect or with respect to the de novo, which is the GAL review where there were no change in placement or visitation orders?
Well, Your Honor, there's a lot to unpack in what Mr. Royal said, and I'm not sure how much of that would actually be relevant at all to address. between the mischaracterizations of what happened at the hearings. I'm pretty sure the court is aware of that. So let's discuss what's happened since the last hearings have happened. There have been doctor's appointments. Let's see, looks like May 3rd, July 13th, and October 26th. He did attend those 3, although he was 15 minutes late on the 26th. There have been birth to 3 appointments. If we just want to go since August, he's been notified of every single one of these appointments. September 5th, September 12th, September 18th, September 25th, October 3rd, October 10th, October 24th, November 6th, and November 20th.
Now, earlier in some of the notes I reviewed last night, I asked Ms. Fontaine to start scheduling those on a date and time that was gonna be more open to his calendar and his school calendar. Was that done?
Yes, it was. They made every attempt to not schedule on Mondays because that was the day that he identified as being the worst. So starting in October, they had a bunch, well, actually starting in September, they had a bunch of Tuesdays, but he did not attend a single appointment. There were supervised visits at Parent Connection in Oshkosh, September 25th, September 27th. There is one scheduled for October 2nd, but Mr. Royal did not show up. They were completed on October 4th and 6th, 9th, 11th, 16th, 18th, 20th, and 23rd. And that looks like that was the last appointment, in part because he stopped paying for their services. It sounded from talking to Brooke as though those visits had mostly gone well. She did note that they asked her one time to bring additional diapers for his use, which I thought was just horribly ironic since he's not paying any support. But those visits seemed to go well, and actually they got better as time went on. She reported to me, and she could testify about this if you want her to, that after the first couple of supervised visits, the child was uncomfortable afterward. He seemed unhappy and more clingy than he ordinarily would be because he had just spent time with a virtual stranger. But as time went on, that got a lot better. And then it came to the point where he had just basically been spending time with another caregiver, and that was great. And then the visits stopped because of non-payment, and now he hasn't seen his father since October 23rd. Well, the 26th was a doctor's appointment. So now there's a concern about what happens now. Do they restart at Oshkosh? She has started working. She works in the Howard Swamico area from 8 to 4. So now it's an additional hardship to get to Oshkosh if that's where the visits are gonna be. We do agree that there were some communication snafus from time to time with them as far as the scheduling was concerned. It would be her preference that any visits take place a little bit closer to her workplace so that she doesn't have to leave work 2 hours early in order to get Sebastian to Oshkosh. In the past, they had tried to work around Mr. Royal's work schedule, and I think that it would be kind of fair to now work between both of their schedules and see what's available. Her family remains quite willing to accommodate supervised visits, whether it's a family member or another friend or somebody else who could perform the supervised visits. You know, they want to keep all of those options open so that Sebastian can know his father. But they're also very concerned that if the court is to say that you don't need supervised visits anymore, you can just have full free access visits, we're gonna have an Amber Alert based on what happened in March. And his subsequent statement saying that once I'm given full custody of Sebastian, you and your family will never see him again. So we do have those concerns. At this time, I guess we would ask that the order remain in effect, but perhaps opening it to visits in a different location. I know that right now it says supervised by family services in Oshkosh or by another third party agreed upon by the parties, but perhaps the court has other ideas or other resources that could be available to the parties in their current situation. I guess at this point, I don't have much more to add unless you want to take testimony from my client.
I don't need to at this point. Attorney Bouchard, your thoughts, unless you have questions for Mr. Royal or questions for Ms. Fontaine?
I guess I have a couple of questions for Mr. Royal based on a couple of the representations
Go ahead.
made here today. Mr. Royal, you had spoken a lot about text messages and whether or not they were admissible. You would agree that the question of some text messages between you and Ms. Fontaine was brought up at the October 30th hearing?
Say that again?
You would agree that there was some discussion of text messages between you and Ms. Fontaine that I had expressed caused me some concern when we were in front of Commissioner Schrader on October 30th?
Yes.
And you were asked at that hearing by the commissioner whether or not you sent those text messages, correct?
Yes.
And you couldn't recall, is that
Yes.
correct? And after the hearing was over, you and I stepped outside the court and I showed you the screenshot I had of a text message that was concerning to me, correct?
At the time, I did not look at it.
Okay. In fact, you didn't look at it because you told me you didn't want to talk to me further without an attorney, is that right?
I said that I believe that I should have an attorney present. Yes.
And we haven't had any contact since then, correct?
Yes.
That's all I have as far as questions for Mr. Royal, Your Honor.
Then your recommendation?
Your Honor, this is something of an odd procedural posture. We did have a review hearing on October 30th. Generally, GAL review hearings are requested and scheduled by the GAL. That was not the case under these circumstances, and that's fine. And there's now a de novo of an order that was previously existing and was previously put in place by Your Honor. I was pleased at the progress that was being made in the supervised visits. And then they were halted. I understand that they are not free and they're not cheap, and that can be an obstacle for a lot of people. Unfortunately, it was something that was necessitated by a couple of things. One, a substantially lengthy gap in contact between Mr. Royal and his son, and the fact that there had been some concerning actions that led to this. We can get into who's right and who's wrong about what happened in March when Sebastian the younger was brought to Milwaukee, but it doesn't change the fact that it happened. And that's not how this should have gone down, and I understand that that's why orders were entered on an emergency and later on an ongoing basis, but there were appellate procedures that could have been followed. And we're here today, I think, relitigating something that has been litigated several times. I'm more troubled by the fact that there's again been no contact between this very, very young child and his father. And this really seems to be something where the dysfunction between the parents is getting in the way of that more than anything else. I know that Ms. Fontaine and her family have offered to assist with supervision. I know that Mr. Royal, not necessarily unreasonably, is uncomfortable with that. That might have been something that would have been better 8 months ago, and that was something that was offered 8 months ago. But I think not only is that water under the bridge, the water's more poison now than it was then. And that, I think, creates some substantial difficulties. But I now have a child who had 12, 14 hours with dad over the course of 5 or 6 weeks, and now has gone another 4 or 5 weeks without seeing dad at all. And it's like we're starting over again. But part of that problem is caused by Mr. Royal, and Mom has repeatedly said, this is when these appointments are. This is when these appointments are. And the text message that I showed to Mr. Royal in response to that was utterly inappropriate, and he has not provided me any commentary or explanation on it. And so I don't have any of my concerns assuaged in this situation. So I don't know what I can rely on today that I wasn't relying on October 30th to suggest that there should be any change other than this kid needs to see his dad. And and that needs to be figured out. It probably doesn't make sense if Dad is now back in the Appleton area to have everybody driving to Oshkosh where nobody lives. But we're also somewhat limited in what services we have access to. And it would be great if the parties could agree upon a third party, but I really think that this is a situation where they won't because the other one suggested it. And that kind of binds my hands. Because the interactions between Dad and son were going well, but there was also mention of a need for regular redirection, because while the interaction between father and son was good, there continued to be negative talk about mom in front of this child. And I realize he's very young and doesn't understand what's being said. It's just completely inappropriate. It doesn't matter. It's not going to help these parents get further down the road. And I know that Mr. Royal cares very, very deeply for this child. There's not a question in my mind. But the negative view, and to a certain extent, both parents have of one another, is something that is going to remain an obstacle to that unless they can literally overcome it.
Ms. Shaha, you're present, but I don't think necessarily to weigh in on any of these issues because they relate to the court's review of placement or the schedule. Mr. Royal, have you tried to reach out or look into any other facilities to do the supervised placements through?
I was not aware of any other facilities other than, other than Parent Connections.
And did you stop using their services because they were just not cost efficient for you, or it was too much?
I was working part-time while going to school full-time, while working part-time while going to school full-time. The amount of money that I make in a week doesn't even cover, the amount of money that I make in a month doesn't even cover the amount they wanted for a month.
Where are you working right now then?
At Walmart,
And then you're still in school at the Fox Valley Tech?
yes.
Well, part of what the court has to do when we come back for hearings such as this is look to see if there's cause or reason to make a change or what has occurred that is different. I have tried to give some leeway, and I think even the family court commissioner did when he scheduled, because there were letters sent, and we then had hearings, where in other cases, Ms. Sturts could have filed an objection to the court, and I think you did at one time, even holding hearing because there wasn't a sufficient basis to have the hearing held. But I've tried to give you, Mr. Royal, an opportunity to come in and present information to me that is new or make argument about what you've been doing and why that should then have me change what I previously set in place. And today, I understand you want me to go back and look at and change decisions about the original order. I should also just comment on one thing you talked about, text messages. How the court allows those used is very different than how counsel and Mr. Bouchard and even Ms. Shaha will review those or look at those. So I think you were upset because Mr. Bouchard was reading them, but then the court said I wasn't gonna allow some. There's different standards of what people can use. So I just comment back to you on that. But to date, there has not been a significant change or presentation of different information that would have me change the prior order. Ms. Fontaine has suggested, and I know it's probably not going anywhere, that you might try to find a third party or someone else. Ms. Sturts, have you thought of any other options that would be more appropriate for the supervised visits, one that would not involve either party driving south, because now Mr. Royal lives in this area? Don't know if you have any thoughts or suggestions?
I had attempted to do some research on what's available in Green Bay, but they would go to a separate location. So they would be going to Brooks' residence, and I understand that that's not acceptable to Mr. Royal.
Okay. Attorney Bouchard, are you aware of any other sources up here or further north that the parties might utilize?
I am familiar with the fact that some of the social workers and the like in Brown County do perform that service, but that they don't have a facility in which to do it. I'm really not, Your Honor, and
Okay.
that's something that's flanked
Lacking.
some of my efforts in other counties as well.
So, Mr. Royal, in terms of those visits, Parent Connection is the option we have. There's not a facility here in Outagamie. I don't think there's one, like a location in Brown even. But if you do some research or find a place or location, provide that to the other side to see if they'd be willing to do that. I don't.
Your Honor,
Go ahead.
sorry about that, but I have ties with the community. I'm saying I have ties with the community. I go to church. I'm tied in with my school and work. I'm saying I'm stable here in Milwaukee. I provide housing for my son. I provide clothes for my son. I have food for my son. I have toys for my son. My whole house is for my son. Everything I own literally is for my son. When it comes, like, there is no threat. There has been no threat. And from the statements that I made, earlier, I'm saying there's no reason that that I should not be able to have my son, at my house for a duration of a time, and there's no reason that I should not have my son in my house for a duration of a time, and I would still suggest that it's best to try it out, see how things go. Because without any, it's like the court has told me on several occasions, without any facts or evidence, otherwise stating besides, without any facts or evidence, I'm saying there's nothing really here showing any concern whatsoever. I'm an outstanding citizen. I'm saying I've never had a record, I'm saying what is the reason what is the reason for me not receiving 50% custody or any type of custody other than visitations?
I've made my ruling on that. You've asked me almost every time we're here to go back and rehash that. I'm not going to. What I'm trying to come up with, Mr. Royal, is telling you at this point the visitations still need to be supervised. I'm trying to pick everybody's brain to figure out where we can have that happen. Yes. Or how we can have that happen.
I completely understand that. All I'm asking is why are there supervised visitations?
For the reasons and the evidence that was presented to this court prior when I made that ruling, nothing has changed. We then tried to set up supervised visits so we could see how that would go, how the interactions would go.
Which you did.
There was a guardian ad litem review on October 30th. Court commissioner decided there wasn't enough presented to change. You've asked me to review that today, which is what I've done. I still don't see that there's enough information to change what we've previously ruled. So that being said, I'm not changing that. So okay. I'm trying to look at what's in place and how do I facilitate something so you can still have those supervised visits with your son. That's what I'm trying to do, because I know you want that, Mr. Royal. But at this point, I don't think we have any other options in Parent Connection that anyone's aware of. At this point, I'm going to implore on everyone to keep seeking out resources. I'm thinking way outside the box to try to think of, does the Fox Valley Tech have any, I'm not aware of any, but any programs for childcare where they would agree to supervise visits? I don't know that, but I know a lot of times the schools and the universities do, because they try to, but that's more of like you can bring your child and they can attend daycare at those facilities. I don't know that they are parties that want to be supervising visits with people. I don't know that, but you can ask about that, Mr. Royal. If you find out information about that, you can share it with Attorney Bouchard or with Ms. Sturtz, and then they can try to see if that's a different option. I'm trying to think outside the box for you of what else is going to be logistically and geographically easier for all of the parties going forward.
The only other idea I would have would be to have a social worker or retired social worker who provides these services come to a public location like a Pizza Ranch or something like that, but those visits would probably have to be shorter because those restaurants aren't gonna want you to linger for 2 or 3 hours, but that's at least an option.
Or something that could be explored. Attorney Bouchard, any thoughts, any other thoughts?
Well, and of course, that works, but the only issue is that, that obviously creates more cost. If you're
Right.
having to then go to a place and pay for admission or pay for a meal or what have you.
Unless, because I'm just thinking of this, contact could be made with the parties that do that, and maybe they'd agree to do it at a library. Most libraries now have kids' book areas with bean bags and other things that are kind of kid-friendly and at their height. They might even have puppets. I don't think they have extensive toys in the library because they don't want it, but they'd have some things, or you could bring those things in. So Mr. Royal, there may be a cost to have that other program supervised, but we'd be going to a location that would be open to the public, where there's some kid things you can sit down with him, start reading or looking at picture books or other things like that. So I'm trying to think outside the box, knowing no one in this case has money to be throwing around anywhere, but that can be the most efficient and effective. So I'm gonna empower you to try to figure that out or sort through that. Ms. Sturts or Mr. Bouchard, if you know contact information for those workers who agree to go to locations to supervise, please provide that to Mr. Royal so then he can reach out and start talking to them about some options that they may think or consider. So there's places, I mean, the mall even, the Foxborough Mall even has a front play area with a bunch of soft kind of toy things that you don't have to pay to get in, but if you could have some time playing with him. He might be a little small for that, but it's still another area to go. So that's all I can think of at that point. So we're done with that issue. I have to be cognizant, one, of our time, because I have Mr. Bouchard here all afternoon on a divorce.
99% we're stipping.
Okay,
I have it with me. There's no ink on it,
okay.
but I have it with me.
So with that understanding then, do you object if we continue and move into the sanctions part? I'm gonna have to give my staff a break. But then you can talk to the other parties. You're gonna need a break, and maybe we commence that one at 1:20, 1:30-ish
I know my client for the 1 o'clock is in the building,
already? Okay.
so I can go meet with her. I don't know, are you suggesting taking a break now, or are you dealing with the sanctions issue and then taking a break?
I would suggest we go into the sanctions issue. I don't know if you need to be here for that, or if you want to listen in.
I was not involved in the hearing that precipitated the sanctions issue, so I don't think that it would be appropriate for me to add anything
Okay.
unless somebody wants me to.
No, Ms. Sturts?
I have no opinion on that.
Mr. Royal, just like Ms. Shaha, when we were talking about placement, that's not really her role. I didn't get her input. I wanna let Mr. Bouchard leave if we're gonna just talk about sanctions and payment and child support, because those aren't really issues he weighs in on anyways. Then it'll allow him to kind of explain to our 1 o'clock parties what our plan is, and that we might start a little bit later on that one, but as soon as we possibly can. Okay, so I'm gonna excuse Mr. Bouchard at this time. And then, Ms. Sturts, it's your request for a sanctions. Go ahead.
Yes, it is. It's pretty self-explanatory. We have an order that was based on the hearing in early April. It was heard on April 5th. At that time, Mr. Royal represented to the court that he was employed by Bench Tubes and was earning $560 a week. Based on that, his current support was set at $95.20 per week starting March 23rd. That was based on when the parties separated. There is also an arrearage amount, and it also discussed the birth expenses and the cost of service for process. The order also addresses the fees that are associated with going through the child support agency. Since that time, he has paid a grand total of $40. He only made payments after we had the hearing on his request to change the child support order. After he filed his request to change the child support order, I asked for contempt for his non-payment. And during that hearing, it did come to light that based on the amount of time that he had been in non-compliance with the child support order, that he had actually committed a felony. And so the Commissioner Schrader went ahead and advised him of what it takes to not commit a felony. So he did make a payment of $20 within a week or two after that. Then another payment of $5, another payment of $5, and then more recently, a payment of $10. To compare that to his current support that he should have been paying, that amount comes to $3,332. During a great part of this time, Ms. Fontaine was not employed, first because she was caring for a child with some medical issues related to being premature, and then she had her own injury that left her unable to work. So she's only been working for a little bit. She was having to rely on family and friends for the care of this child who, despite any disagreements between the parents, he still needs diapers, he still needs shelter, he still needs food, he still needs clothes. You know, he needs the basic items, and that has not been able to be provided through his father's support. Based on $40, that would buy maybe a box of diapers and a box of wipes. So at this point, we think it is appropriate. You know, he's been held in contempt. He was given purge conditions of complying with the court order for a fairly short period of time. And based on what we've seen, he hasn't even tried. So a sanction at this point would be appropriate. Whatever remedial sanction the court would deem appropriate, we'd be okay with, as long as it means that he gets to support his child. We'd be okay with a jail sanction or whatever else the court would consider appropriate at this time.
All right, Mr. Royal, any response to that request?
Yes. Once again, they have been receiving.
Take your hands.
Sorry about that.
That's okay. No, that's okay.
Like I have been making payments of what I can, but my main supporter is my son. My son has, like I said earlier, my son has diapers at my house that he can freely have at any time. He has clothes at my house. He has food at my house. He has toys at my house. I do provide for my son. Like I said, my home is my son's home, and like I said, I'm just saying, when it comes to providing for my son, my whole life revolves around him. But when it comes to, like I said, when it comes to paying Brooke, when it came down to paying Brooke, I paid what I could for what I was working. Still being able to, support still being able to have those, support myself and, keep those things for my son.
Do you still have diapers at your house?
Yes.
Are they the size he needs right now?
Yep. I even have some in my car with wipes and a car seat.
But my concern is you have the limited supervised visits, and instead of sending additional money in for support, you're spending money for things that are just sitting at your house and not being used.
Your Honor, they can be used whenever my son. I'm saying if Brooke would have asked for them, she freely can ask me send a text to me anytime I ask for him. Like I said, when it comes to my son, I'm willing to go. I'm willing to do backflips for him. And like I said, I'm sorry, I had something else in mind. It just slipped my mind right after that.
If you think of it, let me know.
But yeah, like I said, if Brooke wants to, she could have asked me anytime.
Ms. Shaha?
Ms. Stewart's statements are correct that since the contempt finding, there have been, payments totaling $40. Current arrears right now is $3,016.40, interest of $49.13. And then we have outstanding costs, which are not our concern at this point. He did pay $10 on the 12th of this month, $5 on the 3rd of August, $5 on the 26th of September, and $20 at the end of August. However, his interest is accruing at, last month it was $13.18. So at this point, he's not even paying what the interest is that's accruing. The court at the August hearing regarding child support did find that he had an obligation to support and care for this child. He knew about that obligation when he made the decision to leave his job and start school, and the court found that that was not justification for putting himself in this position. So while he's made payments to avoid continuing violations of a felony nature, where he's not paying at all. So I think that it would be appropriate to set a purge condition. He did not comply with the prior purge condition, which was to pay as ordered for the next 90 days. I think that a purge condition of a requirement to pay a lump sum plus remain current in payments within, 30 days, or face a jail sanction is appropriate, is what we asked for if we would have filed the motion.
And that's typically what I see, Mr. Royal, just so you understand, because every week Ms. Shaha has contempt hearings between the 7 different circuit court judges. And what's typically done is for those cases where someone has not been paying, they come in and try to work out an agreement with the person or sort out why the person hasn't been paying. And then what they typically require, because if I find you in contempt, which Commissioner Schrader has already done, I give you the opportunity to purge your contempt, which means like earn your way out of that finding. But there has to be something meaningful done to earn that purge. If you don't meet the condition, then we impose jail time, which I don't really ever get a huge joy out of imposing jail time in child support cases, because I want the person out and working. But sometimes the parties, the only way I know they're gonna work is if they're sitting in jail and their only option to get out is to go out and work. Do you think you can make a more significant payment by January 1st?
Your Honor, I work a certain amount of hours a week. Like I said, my schooling is important to me and my son, because that's the only way I can, fully, like, me graduating, me making a better income. That's what it is for my son. You know what I mean? That gives my son that better life. I'm saying I can't just sit back and do these part-time jobs, these small-time positions. You know what I mean? That's not in the best interest of my son. What's in the best interest of my son? Me to do what I have to do, the best that I can do, so that he can have the best what he can have. And if it takes me working a little part-time job, for the time being, that's what I have. If I'm saying I can't afford to make payments in which I can't afford, but I'm saying I can only afford to pay what I can afford to pay while still being able to keep my bills, and everything else up. Like I said, and keep stuff for my son. I guess that's pretty much it.
Runner, if I could jump in at this point. At the August hearing, he represented that the entire time he was in Milwaukee, up until just 3 days before that hearing, he had been employed. He was living with family, so he wasn't paying rent, and he was employed. It was my understanding that he was employed full-time. And during that period of time, he paid $0.00. It's not about what he can afford, it's about his choices that he's made.
You're
and
right.
He has chosen not to support his son, and that's unacceptable.
Your Honor, she is right. I did not pay when I was in Milwaukee. I'm saying I'm not excluding that, because my main concern was getting up to here closer to my son. So that I'm saying all of that money that I earned, which I've only worked there for a few months, but all that money that I earned was to move up here to get a house. Prior to what the court wanted, they said it was in the best interest that I come. No, they said it wasn't in the best interest that I moved to Milwaukee, and that it would be in the best interest for me to move up here. So.
Well, given the non-payment that has continued to occur, I am gonna find you in contempt of the court's order. I would note specifically, Commissioner Schrader tried to give you those purge conditions on the August hearing that was held on the 17th. But you've still not complied. I'm gonna order the following purge condition because it's consistent, Mr. Royal, just so you understand with what we do with all the other cases come in, had the request come from the child support agency, which I wanna treat your case like I treat everybody else's case, just so you know, and not the request or the filing came from Attorney Sturts on behalf of Ms. Fontaine, but the purge condition is going to be Ms. Shaha. I'm gonna ask for your input, given the amount of arrears that have collected